Oftentimes, when a taxpayer may become subject to IRS fines and penalties, they'll do their due diligence and their research, and they'll learn that if they can show reasonable cause, then they may be able to avoid penalties. When a taxpayer can show that they operated with reasonable cause, then the IRS is no longer empowered to assess penalties for whatever violation the IRS is assessing penalties for. Now, sometimes the taxpayer may not qualify for reasonable cause for one reason or another. The particular agent, just the way that they interpret reasonable cause, it may differ from one agent to the next. And if you're unlucky, well, do you have any other options? And typically you may. So a couple of things to keep in mind is even if you don't qualify for reasonable cause, a couple of things to look at. One, did the statute already expire? The statute of limitations expire so that the IRS is no longer empowered to issue penalties. Two, even if you don't qualify for reasonable cause, like in an FBAR situation, you may qualify for non-willfulness. And with non-willfulness, the IRS is often open to negotiating a penalty reduction or even a penalty waiver, mitigating penalties. There's something called the first-time penalty abatement. Now, that doesn't work for everything, but for some types of penalties, you may be able to get abated first time. And alternatively, even if you don't qualify for the FTA, if it's your first time having to file a form like a 3520, then that may go a long way in convincing the IRS to avoid, minimize, or reduce penalties. And finally, IRS error. Everyone makes mistakes, including the IRS, so it's important to review how the IRS came up with your penalty to determine whether it was issued in error or not.